What happens when a defendant walks into court and refuses to even admit who he is? In today's unbelievable courtroom showdown, a judge faces a man using unusual legal theories, challenging the court's authority, and dodging nearly every direct question. But here's the twist: the judge isn't backing down. Every refusal, every interruption, and every argument pushes the situation closer to disaster. Will the defendant cooperate, or will these courtroom tactics land him right back behind bars? Stay with us, because this case takes a dramatic turn that only gets more intense as the hearing unfolds.
I'm sorry, speak up so I can hear you.
Today.
You're appearing here today, or at some point in your life prior to being this third party, were you Nir Brown?
No.
You're not him.
I'm third party interview.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown, because I'm not going to say all the words that you just said, because you have now identified yourself as Nir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 03322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323.
This is one of those moments where courtroom procedure really matters. The judge isn't debating personal beliefs or unconventional legal arguments. She's trying to complete the required steps of an initial appearance. Before a case can move forward, the court must identify the defendant, explain the charges, and address legal rights. By repeatedly interrupting and refusing straightforward answers, Mr. Brown is creating more obstacles for himself than for the court. The judge has already made it clear that these tactics won't change the legal process. What do you think? Is this a smart legal strategy, or is it only making the situation worse? Let us know your thoughts as this hearing continues.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'll block.
You'll oblige.
I'll block. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court, and take care of those things before the next court date. All right, step in front of the clerk. Nir Brown. Are you Nir Brown?
I'm sorry. I think we were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, Your Honor.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do have.
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is foreign age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen.
This hearing ended with a powerful reminder that courtroom orders carry real consequences. Throughout the proceeding, the judge repeatedly gave Mr. Brown opportunities to cooperate, identify himself, follow bond conditions, and show that he had made a genuine effort to secure legal representation. According to the judge, those instructions were not followed, leading to a major increase in bond and an order to return to custody. The exchange also highlights how challenging the court's authority without complying with basic procedures can quickly escalate a situation. Whether you agree with the judge's handling of the case or think the defendant should have taken a different approach, it's certainly a courtroom moment that has people talking. If you found this case as shocking as we did, make sure to hit that like button, share your opinion in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, dramatic legal moments, and unforgettable courtroom confrontations.